Joinder of parties. Parties can be joined in a single complaint or may themselves maintain or be sued in separate suits. Normally, joinder of parties is permissive. It has the following requisites. Number 1, the right to relief arises from the same transaction or series of transactions. Second, there is a question of law or fact common to all the plaintiffs or defendants. And third, the joinder is not prescribed by the provisions of the rules on jurisdiction and venue. The rules provide that all persons in whom or against whom any right to relief in respect to or arising out of the same transaction or series of transactions is alleged to exist, whether jointly, severally, or in the alternative, may, except as otherwise provided in the rules, join as plaintiffs or be joined as defendants in one complaint where any question of law or fact common to all such plaintiffs or to all such defendants may arise in the action, but the court may make such orders as may be just to prevent any plaintiff or defendant from being embarrassed or put to expense in connection with any proceedings in which he may have no interest. Question: is there compulsory joinder of parties? A joinder of a party becomes compulsory when the one involved is an indispensable party. The rules provide that parties in interest without whom no final determination can be had of an action shall be joined either as plaintiffs or defendants. These are the indispensable parties. Where an indispensable party is not joined as a party to an action, the court shall order that he be joined as a party to the action. Now, what if there is a misjoinder or non-joinder of parties? Well, the rules of court provide that neither misjoinder nor non-joinder of parties is ground for dismissal of an action. Parties may be dropped or added by order of the court on motion of any party or on its own initiative at any stage of the action and on such terms as are just. Any claim against a misjoined party may be severed and proceeded with separately. Let us compare the difference between non-joinder of indispensable party and non-joinder of necessary party. So when there is a non-joinder of an indispensable party, the court will order that that party be impleaded. When there is failure to obey the order of the court, then it can cause the dismissal of the case on the ground of violation or failure to obey the order of the court. On the other hand, the non-joinder of necessary parties do not result in the dismissal of the case. Non-compliance with the order for the inclusion of the necessary party would not warrant the dismissal. This is an exception to Section 3, Rule 17, which allows the dismissal of the complaint for failure to comply with an order of the court, as Section 9, Rule 3 specifically provides for the effect of such non-inclusion of a necessary party. And the effect is, it shall not prevent the court from proceeding in the action, and the judgment rendered therein shall be without prejudice to the rights of such necessary party. Section 11, Rule 3 likewise provides that the non-joinder of parties is not a ground for the dismissal of the action. For emphasis, please take note that misjoinder and non-joinder of parties are not grounds for the dismissal of the action. When the court orders the joinder or dropping of a party and it is not obeyed, the ground for dismissal will be the failure to comply with the court's order under Rule 17. Nonetheless, if the court ordered the inclusion of a necessary party and it is not obeyed, it will not prevent the court from proceeding with the case. So take note that the order to include an indispensable party, if it is not obeyed, then the case, or it can be a ground for the dismissal for failure to comply with the court's order.